Good morning to all. Welcome to the third Professor Shamnad Basheer Memorial Lecture organized by LiveLaw. We are here to celebrate the legacy of Professor Shamnad Basheer, who used his academic brilliance and activist zeal to expand our fundamental rights jurisprudence. His initiative, the IDIA, continues to help students from marginalized sections to access legal education and has brought in diversity to our classrooms. Professor Shamnad Basheer had a special relationship with LiveLaw. He was a part of our academic advisory council right from the beginning, and he was our guide and well-wisher. His departure is a personal loss for Team LiveLaw. That is the reason why LiveLaw has started this initiative to keep the memories of Professor Shamnad Basheer alive. We are joined by a very special guest today. I welcome Dr. Justice Dhananjaya Chandrachud, Judge of the Supreme Court of India, who will be delivering the memorial lecture today on the topic, Making Disability Rights Real. Justice Chandrachud, like Professor Shamnad Basheer, is someone who uses his legal knowledge to empower the weak and the marginalized. This can be seen from several path-breaking judgments authored by Justice Chandrachud. Due to paucity of time, I can cite only very few examples. For example, in the case Prince J.B. Singh, Justice Chandrachud came to the relief of a Dalit boy who lost his IIT admission since he could not pay online fees at time. His recent order passed in the case X versus Principal Secretary, where an unmarried woman was permitted to seek abortion of a 24-week term pregnancy. That is a fine example of balancing equity with law and compassion with judicial pragmatism. Likewise, the recent direction given in the case Shanvi Ponnuswamy versus Ministry of Civil Aviation for ensuring employment opportunities for transgender persons is another notable example. So be it gender rights or rights of sexual minorities or disability rights, we can see that the judgments of Justice Chandrachud leave a new imprint. We are also joined today by Mr. Vikram Raghavan, the lead counsel at the World Bank, who was the batchmate of Professor Shamnad Basheer at the National Law School. First, I invite Mr. Vikram Raghavan to share a few words of his thoughts and memories about Professor Shamnad Basheer. Over to you, Mr. Vikram Raghavan.
Thank you, Manu. I want to thank you as well as Rashid for inviting me, and it is an honor to share this stage even briefly with Justice Chandrachud, for whom I have a great personal respect and regard, more than for all the reasons you mentioned in terms of judgments, but also for his integrity and for his simplicity and humility, which I think is a role model for all of us. And in that respect also reminds me of my great friend Shamnad, whose memory we commemorate today. I got to know Shamnad when he was 17 and I was 19. He was actually 2 batches below me, but that didn't matter because it was a small school and an even smaller gathering of hostelers at the National Law School's men's halls of residence, as it was known. He, I, and many others shared laughs, memories, meals, arguments, and in his and my case, fights on the judo mat. We actually took judo lessons for the first 2 years that he was in law school with, which is an experience I think very few others have in common. But he touched us, all of us, very profoundly with his deep personal connections and intimacy that's really hard to explain in words. He lit up the campus and the room with his presence. He had a supermodel's physique, but it was tempered with a great accessibility that came from his laugh, from his sense of humor, and just that presence which was really hard to describe. Now, of course, his name means different things for different people. For students, he was a distinguished professor and mentor. For the underprivileged and marginalized, he was a social justice advocate. For foreign contemporaries, and actually it is staggering to learn how many people across the world respect and regard Shamnad beyond our own country. He was a truly globally renowned activist and IP expert. And then for me and many others, a dear friend. he cut his teeth at the law firm of Anand and Anand, and I remember visiting him in that firm, where he was called Shahrukh, which was also a name that the judo coach gave him because, recognizing his looks. But he also still had his sense of humor and his sort of simplicity, even though he worked at a very premier firm. But he realized that his mission and passion lay elsewhere, and so he chose to pursue education, higher education at the University of Oxford, and then had several teaching stints at the George Washington University School of Law, which also brought him back in contact with me in Washington, where I was at that point with him. And then, of course, he returned to India, giving up many lucrative offers because he felt that's where his calling lay. And he then managed to do such a great deal for both Indian law and legal education in the short life that he had. Now, of course, again, this is not meant to be a detailed recitation of all his achievements, but his work in IP, I think, is known. His petition for transparency in the patent office was a crusade that he took up. And then, of course, in 2015, he won the challenge on the constitutionality of the IPAB. Students will remember his role in the Delhi University photocopying case. And he filed a number of public interest litigations, really trying to put the law, which he learned in law school and practiced briefly and then taught, into action. Shamnad also had a great penchant for writing, right? He really believed that one must write and express oneself clearly, but also widely in order for one's views to be disseminated and to have an impact. He was a founder member of the blog Law and Other Things, one of India's first law blogs that some of us started, and a core member of the team. In fact, preparing for this lecture, I went back and read the hundreds of emails that he exchanged on small things like the font of the blog to the content, what should be our public comment policy. And that love for public engagement through blogging sort of led to his creation of Spicy IP, which also was a great pioneer in the way that legal discourse was disseminated. Right, until then, it was very much a sort of a journal-bound discipline, which he popularized by open access through blogging, and did so in a very simple and lucid way without unwarranted legal jargon. And therefore, Shamnad was sort of not just a believer in that old adage of practice what you preach. He followed it and championed that dictum in whatever he did. And therefore, for his friends, he always had many friends, but he was very generous about them. He made my introduction to Rashid because he really felt friends were unrivalrous, right? The more friends you have, and introduce your own network grows. His knowledge, of course, was boundless. We argued about the property jurisprudence in the Constitution, but he always also felt it was important to share. And then sharing not just knowledge, but also the meager resources he had and advice on matters personal and professional. Now, in 2010, of course, he started teaching at the WB NUJS, West Bengal National University of Juridical Sciences, where he served as the Ministry of HRD's professor of IP law. But again, he felt that the national law schools, of which he was a product and now a participant in, lacked diversity, which then led him to this unprecedented initiative, IDIA, which Manu mentioned, which I think many of us didn't realize the scale and significance of this initiative until much later. But at IDIA, diversity and representation were core values, and it was something that he really stood for in everything he did. Now, IDIA, of course, has several success stories. Today, IDIA's scholars work in top law firms, in think tanks. They litigate across the courts in the country, including the Supreme Court. They've pursued higher education in the world-renowned universities and even contested the 2019 Lok Sabha elections. But these IDIA graduates are Shamnad's proteges. They represent his living spirit, which, of course, is still with us. And in a way, he really built this initiative as he battled serious health challenges. And watching him do this, build this initiative was a great source of strength and inspiration for all of us who met him. And he left, therefore, 1,000 flowers to bloom through the IDIA initiative that has given the promise of legal education, but also participation in public life to so many of those who are disadvantaged and otherwise marginalized. Now, again, Shamnad, as I said, adorned various hats throughout his life for lawyers. He created IP jurisprudence and was a litigant, was an advocate for causes. He was also a spiritual guide and mentor. I think that's a part of Shamnad that many of us forget. He was a deeply spiritual guy who actually used his spirituality to nurture and nourish his soul, in a sense that every time he felt he needed to recoup and rejuvenate himself, he would migrate to an ashram where he really enjoyed time in solitude. And that spirituality, again, is another thing that deeply stirred me. We can go on, but I think I'm grateful that we had this opportunity. I want to close with a personal anecdote, which is a bit fitting, but also a little, it is somewhat melancholic. A few months before he passed away, the famous professor of Indian constitutional history, George Gadbois, passed away after a long illness. And I sent Shamnad the draft obituary that I wrote for Gadbois, because, as I said, Shamnad was a friend, but also a good sounding board for any thing I wrote. And he wrote back a very interesting response, which I will just share it, the 2 lines. He said, well, this piece lacked the spirit that you've infused in your previous writing, especially your obituary on Granville Austin. Where is the soul in this writing? He asked me. I want to see the soul of the person. And I think that is something that was a good reminder to me that Shamnad really cared passionately for the soul, for the spirit. And I hope we can carry forward his legacy and imbibe the zest he had for life. Thank you very much again, Manu.
Thank you, Vikram, for your heartfelt remembrance of Professor Shamnad Basheer. Now let's listen to Justice Chandrachud's lecture. Over to you, sir.
Thank you. A very good morning to Mr. Vikram Raghavan, Shamnad Basheer's family and friends, and everyone who has logged in this morning to participate in the event. I'm truly honored. Professor Shamnad Basheer Memorial Lecture today. Thank you to the Live Law team for organizing this annual event and for inviting me to deliver the address this year. Events like this help us keep Shamnad's memory alive. August 2022 marks the 3rd anniversary of Shamnad's tragic and untimely death. He was an illustrious scholar, a respected educator, and a change maker par excellence. He was appointed as the Professor of Intellectual Property Law at NUJS, where he was loved by the students, not only for his expertise on the subject, but also because he took on the role of a friend and mentor. Spicy IP, one of India's most widely read blogs on intellectual property law, was founded by Shamnad. But beyond his academic achievements lies IDIA, or the Increasing Diversity by Increasing Access program, what many would term as a crowning glory of Shamnad's achievements. IDIA has the potential to transform the feudal structures of the legal profession by democratizing them and making them inclusive. As the audience today is no doubt aware, IDIA was a movement that Shamnad spearheaded over 2 decades ago with the aim of ensuring equitable access to legal education in the country. The legal profession boasted of a centuries-old presence in India, but its higher echelons, and for that matter its lower ones, remained largely inaccessible to common persons. Although the advent of the national law universities changed the notion that the legal profession was for the few and not for the many, legal education continued to remain the domain of the elite. IDIA, through its consistent efforts, has attempted to remedy this systemic flaw and has succeeded in doing so. IDIA prepares young students from marginalized communities for law entrance exams, secures funding for their legal education, and mentors them through their 5 years at university. To influence the course of even a single person's life is a remarkable thing. That Shamnad influenced the course of so many people's lives so positively is nothing short of extraordinary. I had the pleasure of meeting Shamnad at IDIA's annual conference about 4 years ago, where I was invited to deliver an address on law and storytelling. In echoing his human qualities, he tasked me to speak on this deeply human subject of law and storytelling. Through stories of justice and injustice, we attempted to weave a common vision. True to its names, IDIA's programs targeted persons with disabilities as well. Of the 86 students currently reading law in universities across India, 15 of the scholars are persons with disabilities. Shamnad and others working with IDIA's organizational team have already put into action the theme of today's lecture, making disability rights real, addressing accessibility, and more. My congratulations to the IDIA team and to all its scholars. I wish you continued success. By including persons with disabilities within the ambit of its outreach and training programs, Shamnad as well as IDIA recognize that persons with disabilities are just as deserving of and entitled to an education as the next person. It is not just any type of education that they ought to be able to access. They must have an equal shot at the best universities and the most sought after opportunities. A person can either be born with a disability or become disabled later in life. They can be physical, mental, intellectual, learning-based, or communication-based. Some disabilities are immediately visible, while others are invisible. You will not know about them unless the person in question chooses to tell you. Many chronic illnesses are also disabilities. The effect that each disability has varies based on a multitude of factors. When people encounter others with disabilities, there is a tendency to view them as being very different from able-bodied people, as being lesser than them. By this I mean that they are stereotyped as being less capable and less intelligent than their able-bodied counterparts. The stereotypes that persons with disabilities are burdensome or are defenseless victims also prevail in society. The differences between able-bodied people and persons with disabilities, both real and perceived, give rise to immense stigmas in society. Children often bully their disabled classmates, and friends and adults with disabilities too are not treated with respect or empathy. It is also rather unfortunate that able-bodied persons discriminate against persons with disabilities and in many instances commit acts of violence upon them. The prevalence of these harmful stereotypes has a pernicious effect and hinders access to educational spaces, public spaces, employment opportunities, as well as to free and full participation in society. Beyond hampering their access to those opportunities to which they are entitled, such stereotypes also have the effect of dehumanizing each complex individual and reducing them to a fragment of all that they truly are. Such stereotypes are based on a denial of a person's rich inner life and of their individuality. Other, more material barriers also stand in the way of persons with disabilities. Despite laws mandating disability-friendly infrastructure, public transport, government and private buildings, hospitals, libraries, parks, and a host of other spaces continue to be inaccessible to persons with disabilities. Some entities do not even pretend to comply with such laws, while others comply with them in a desultory fashion and only with a view to getting their building and occupancy permits. I've noticed that some ramps are so steep that an able-bodied person cannot walk down without falling over, let alone a person who uses a wheelchair or crutches. This is just the tip of the enormous iceberg of problems with the implementation of disability-friendly policies. I recently came across a story narrated by the famous disability rights activist Javed Abidi. Parts of this story were also reported by several media houses at the time. In 2001, Professor Stephen Hawking visited India to deliver a lecture. Mr. Javed Abidi, a disability rights activist, wrote to him and requested him to help with the disability rights movement. Professor Hawking declined, but informed Mr. Abidi that he was going to visit the Qutub Minar and other monuments in Delhi. Abidi and his colleagues promptly approached the Archaeological Survey of India and requested them to install ramps at these historic sites that were on Professor Hawking's agenda. ASI is reported to have refused, and the press picked up this story in no time. The Archaeological Survey of India then sat up and took notice of Professor Hawking's visit, built ramps overnight, and installed them at all the monuments. Professor Hawking and his spouse Elaine visited the Qutub Minar, where she put her arms around the iron pillar to make a wish. She was asked what she wished for, and she replied, "I wished for the ramps to stay even after we leave." 2018, but his legacy endures, just like Shamnad's. It is incumbent then on all institutions, be they governmental or private, and all individuals to do their bit to ensure a more just world for persons with disabilities. Governmental or private entities must ensure that laws and policies are being complied with. This is of the foremost importance. In our individual capacities, the least we can do is accord persons with disabilities the respect they deserve and to treat them as equals. The disability rights movement has always maintained that they do not want pity and they do not want to be treated as inspirational figures for merely existing. Instead of being spoken to and treated in a patronizing fashion, persons with disabilities require equal access to opportunities at school and work, an equal chance at forging bonds of friendship, an equal chance to marry and have children if they wish, and to social acceptance. Persons with disabilities have asked to be treated like any other person. In the movie, titled Margarita with a Straw, the protagonist, Laila, is a young student who has cerebral palsy. To those who are yet to watch this movie, don't worry, for there are no spoilers ahead. In fact, one of the allegations, the charges which are leveled against me in the family dining room is that when I tell a story of a book or a movie, I spoil the story right at the outset. So I'm going to make that exception today. Well, in the movie, Laila participates in a music competition with her band and is delighted when the band is declared the winner. But her joy is short-lived. The judge of the music competition is quick to share that they awarded Laila's band the first place because Laila, a disabled person, wrote the lyrics. The undertone is clear. The judge pities Laila, and the award is a consequence of the pity she feels. Of course, Laila is unhappy with the turn of events. This is a story for me as well and for all other judges in the country, that when we do justice to the disabled, we do justice not out of pity, but justice in recognizing their rights under the law and under the Constitution. It is not pity that persons with disabilities require, but the entitlement to be treated as equals. We must also aim towards a just society which accounts for their needs and provides facilities to accommodate them. These facilities ensure that they are able to exercise their rights and enjoy their freedoms on an equal footing with able-bodied people. These facilities, which are known as reasonable accommodations in legal terms, must not be viewed with contempt or derision. Such accommodation, as the law calls it, is based on the fundamental precept that without it, the quest for dignity and equality for the disabled would be illusory. Some people ask, why do they need special treatment? The disability rights movement has long advocated against the position that they have special needs. They only have human needs, the fulfillment of which would enable them to participate in society on an equal basis with able-bodied or neurotypical persons. Each one of us has needs. This is an undeniable facet of human experience. What we need may vary based on our circumstances, but each of us requires something from society at some point in our lives. A few examples of able-bodied persons who commonly require some or the other accommodation are pregnant women, babies and children, women who menstruate, elderly people, people with illnesses, or single parents. By listing these examples, I do not mean to diminish the difficulties faced by persons with disabilities. On the contrary, I'm making the limited point that to require accommodation and not a special need. My court has been continuously engaging with the University Grants Commission for ensuring that all law schools in India have infrastructure which accommodates the needs of the disabled. The able-bodied adult male must not be classified as the standard or the norm, with all other groups thought of as a deviation. The spirit of our Constitution accounts for the rich tapestry of human experience. The one standout feature which animates our Constitution is that it accommodates every human condition and experience. Disability rights cannot be perceived in silos. Kimberly Crenshaw coined the term intersectionality in the context of oppression. In this context, it means that various factors such as gender, sexuality, caste, or class intersect with one another and result in unique forms of discrimination. Much closer to home, towering figures such as Dr. Babasaheb Bhimrao Ambedkar applied an intersectional lens in their writings much before the term intersectionality came into play into international jurisprudence. Intersectionality of human experience is the theme of much Indian folklore and literature. Let us consider intersectionality in the context of disability. If a child with a disability is born into an affluent family, the family will be able to afford expensive prosthetics if required, the best medical care, and the resources to care for that child at home. Now consider a child who is disabled in a much poorer family. How will the parents afford expensive treatment or schools which are equipped to teach the child? If both the parents are working, how will they be able to afford to care for the child at full time? If a public bus is not disability friendly, it is very likely to impact the child with lesser financial resources much more than it will impact the child whose parents can afford a car or a taxi. So the asymmetries in society are considerably enhanced by the engagement and interface with disability. How do we begin to address the impediments to making disability rights real? Of course, a small but significant aspect is society's attitudes towards persons with disability, as I just mentioned. Institutional changes are necessary as well. In the context of the judiciary, sensitivity and empathy are of the utmost importance. Judges would do well to remember that a person with disability who may be before them is a person first and foremost. We had to overrule a judgment of the Supreme Court which had upheld the denial of entry to the visually challenged into judicial service. The fact that such a denial had been accepted in our jurisprudence shows that there is much work to be done in our minds and in our hearts in combating disability. Where the law contains provisions for persons with disability, they must be followed without exception. Section 164(5) capital A of the Code of Criminal Procedure 1973 is a good example of a disability-friendly provision. Section 164(5)A permits the magistrate to take the assistance of an interpreter or a special educator to record the statement of a person with disability. Where such enabling laws do not exist, judges would do well to do what they can within the bounds of the law in recognition of the needs of the person, the human being before them. In a broader sense, Article 12 of the Disabilities Convention recognizes that persons with disabilities have equal recognition before the law. However, if we look at the legal history, we see that law restricts the legal capacity of persons with disability to make decisions about their bodies and lives by appointing substitute decision-making regimes such as guardians or conservatorships. Such restrictions stem from the assumption that mental capacity is necessary to exercise legal capacity. Even presently, there are many laws in operation which deny legal capacity to persons with disabilities. The United Nations has urged that persons with disabilities have the same rights as able-bodied persons to make decisions about their lives. The ability to hold rights and exercise them lies at the core of every individual being. If this is the case, then arbitrary restrictions on the exercise of legal capacity deny persons with disabilities equal protection before the law. By doing so, the law deprives them of a whole host of rights, including civil, political, social, economic, sexual, and reproductive rights. In Suchita Srivastav versus the Chandigarh administration, The Supreme Court held that the state must respect the personal autonomy of women with mental disabilities to make reproductive choices, including the right to terminate her pregnancy. In case of persons with psychosocial or cognitive impairments, the state must refrain from taking decisions on behalf of persons with disabilities. Instead, the state should positively support persons with disabilities to exercise their rights to the fullest possible extent. Our Constitution protects the full enjoyment of fundamental freedoms and the rights of persons with disabilities. This protection is inherently grounded in the principle of the dignity of the individual embodied in the preamble. Persons with disabilities have the right to life and liberty in Article 21 of the Constitution. This also includes all the concomitant sets of rights, such as the right to education, the right to a clean environment, the right to livelihood, the right to shelter, amongst others, that enable an individual to live life to its fullest extent. Exercise of all the rights and freedoms is necessary for social participation and the enjoyment of citizenship by persons with disabilities. To live a dignified and an independent life, persons with disabilities should be able to seamlessly participate in the community on an equal basis with others. Today, I wish to focus on two specific aspects integral to the full development of life: education and livelihood. With a view to realize the right to education of persons with disabilities, the Rights of Persons with Disabilities Act 2016 mandates reservation of at least 5% of total seats for persons with benchmark disabilities in all government institutions of higher education and other higher education institutions receiving aid from the government. However, the reality is that most schools and higher education institutions in India do not account for any reasonable accommodation that persons with disability might require. This puts an extra strain on students with disabilities who have to conform to the existing able normative rules to succeed academically. Our weekly caseloads in the Supreme Court are replete with instances where, for instance, a student with a disability is denied admission to medical college on an assessment of the percentage of disability. Behind cold computations of disability made on the examining tables of public hospitals lies a human story of quest and aspiration. Percentages, after all, are not unfailing guides to human potential. The true realization of the right to education of students with disabilities is possible only in an inclusive and accessible education system. The lack of physically accessible schools, trained teachers and facilitators, and inadequate learning materials excludes students with disabilities from accessing education on equal terms with others. We as a society need to understand the educational needs of students with disabilities and address them in a collaborative manner to help them realize their right to education. Similarly, the right to work is fundamental to recognizing other human rights, including the right to live with dignity and the right to livelihood. Indian law fosters greater participation of persons with disabilities in organized employment by providing them with reservation in government jobs. The law also mandates the government to provide incentives to employers in the private sector to hire persons with disabilities to compose at least 5% of their workforce. Yet, it took the Supreme Court several years of engaging with the government in a PIL to ensure that the posts which are earmarked for the disabled were identified by all government departments and publicly notified. The right to work of persons with disabilities should not be limited to their participation in the workforce. According to the Convention on the Rights of Persons with Disabilities, the right to work of persons with disabilities includes the right to gain a living by work freely chosen or accepted in the labor market, and a work environment that is open, inclusive, and accessible to persons with disabilities. The constitutional precepts of the right to dignity and equality require public and private employers to do more to make their workplaces inclusive and accessible to persons with disabilities. An inclusive workplace entails creating an environment suited to the needs of persons with disabilities, where people feel welcomed and comfortable, not in spite of their disability, but because of their disability. Public and private employers must also ensure that persons with disabilities develop skills during their employment and have access to meaningful opportunities to progress in their careers. Technology can play an essential role in creating inclusive and accessible workplaces. Emerging technologies such as artificial intelligence and the persons with disability to effectively participate and engage in the workspace. However, along with the adoption of technology, we as a society should also introspect on the way our workplaces function. As a starting point, we could ensure that persons with disabilities are not ostracized in the workspace. We should make them feel that they belong and are an integral part of the workplace. Creating a sense of belonging in the work environment recognizes the right of persons with disabilities to work on an equal basis with others. In the legal fraternity, we need to ask ourselves, is the legal profession providing reasonable accommodation to persons with disabilities? Fostering an inclusive and accessible environment at courts will certainly trickle down to society, as courts, at the end of the day, are public spaces where society interacts and engages with its members. At the Supreme Court, our endeavor has been to make our processes and systems accessible to persons with disabilities. The E-Committee of the Supreme Court has been working to make the digital infrastructure of the Indian judicial system more accessible to persons with disabilities. We have introduced audio captures on the Supreme Court as well as High Court websites to ensure that the visually impaired professionals face no hindrances in looking up the cause list or the case status. We have also ensured that case files are readable and screen reader friendly to make them accessible to persons with disabilities. The E-Committee, in collaboration with the National Informatics Center, has also created a judgment search portal accessible to persons with disability. Over 75 lakh judgments of the high courts will be freely available for access. The visually challenged will not have to confront the unwillingness of private software developers to accommodate their needs. With the Supreme Court of India poised to join the National Judicial Data Grid in the near future, all decisions of the Supreme Court will be available in a free text search format which has accessibility built into it. Through the initiative of the E-Committee, the High Courts of Odisha and Kerala have adopted the paperless court systems. The digitization of files and court records will ensure that courts remain accessible to persons with disabilities. We have also tried to make the Indian judicial services more inclusive by removing barriers to the entry of persons with disability. In Vikash Kumar versus the UPSC, we held that the exclusion of persons with over 50% visual impairment from qualifying for judicial services was not in consonance with the reasonable accommodation principle enshrined in the Persons with Disabilities Act 2016. Of course, I will be the first to admit that much needs to be done to make our judiciary fully accessible to persons with disabilities. But I can say that at least we have taken the first steps in the right direction. My hope for the future and a wish to the genie, if I may, is that our country will see a counterpart of the visually challenged South African judge of the Constitutional Court, Zak Yaqub, and many more in the high courts and in the district courts, besides, of course, in the Supreme Court of India. The legal arguments that take place in a courtroom are often backed by substantive legal research, which forms an integral part of any legal professional's lives. Legal databases form an ineluctable part of legal profession, both for the academicians and professionals alike. However, most legal databases are inaccessible to persons with disabilities. The presence of access barriers, such as unlabeled links, non-screen reader-friendly web pages, and PDF files, and the absence of alternative text descriptions for images on websites and blogs casts a chilling effect on the ability of persons with disabilities to produce quality scholarship and practice law. As a fraternity, our failure to provide for reasonable accommodation to persons with disabilities invalidates their everyday struggles. They are unwelcome in the legal profession. This in turn shapes their social reality within which they are constrained to lead their professional lives. The physical barriers are often symptomatic of an ableist attitudinal mindset. Ableism is systemic and rooted in the idea of preference for able-bodied and able-minded persons at the cost of discrimination and oppression of persons with disabilities. Disability is a social construct. The notions of normalcy and intelligence are deeply rooted in centuries of prejudice against persons with disability. We need to understand the experiences of persons with disability in order to change our own attitudes towards disability. Ableism is widely prevalent in our everyday lives. In popular culture, disability is often essentialized to draw cheap humor. Treating disability in a cavalier fashion dehumanizes and stigmatizes persons with disability. Ableism can also take the form of inappropriate and harmful language. Language shapes the way we think. It has the power to define the way we interact and value others. Inappropriate or derogatory language can make persons with disability uncomfortable and act as a barrier to their full and meaningful participation in all aspects of society. Therefore, a good starting point to fight against ableism is to unlearn our language by excluding the ableist slurs that often innocently slip from our mouths in everyday conversations. In the legal profession, law schools could take the lead in tackling ableist environments. If we truly believe that the products of law schools have a role to play in guiding law and policy making, we need to address the failure of our law schools and institutions to provide reasonable accommodation to persons with disability. This affects their ability to assert themselves and contribute effectively to the legal field, resulting in the creation of a legal fraternity that is largely under-inclusive. The invisibility of the identity of persons with disabilities within the legal fraternity is an affront to the constitutional guarantees of equality and non-discrimination embodied in our Constitution. It is difficult for students with disabilities to avail of internships with law firms or participate in international and national moot court competitions. This is essentially because most of their energies are spent in trying to overcome and interact with an ableist structure around them in order to fulfill their everyday necessities. The lack of reasonable accommodation constrains persons with disabilities to shape their entire lives within the interstices of an ableist environment. This can stifle their aspirations. IDIA has launched the IDIA Disability Access Program, through which it sensitized, trained, and supported many students with disabilities. I'm happy to note that multiple national law universities have collaborated with IDIA as part of this IDIA Disability Access Program and are taking active steps to tackle accessibility barriers. I would particularly like to mention the Shamnad Basheer Accessibility Labs at Nalsar University of Law and at NUJS West Bengal. The labs are a laudable effort to carry forward Professor Shamnad Basheer's legacy by ensuring the creation of an enabling environment for students with disabilities. Before I conclude, I would like to extend my deepest gratitude to all the disability rights movements in the country and the world over. It is due to their tireless work that I am able to speak about some of the themes discussed today. Thank you, everyone, for listening to me patiently. It is my pleasure to have delivered this address today in homage to the life and the legacy of Shamnad Basheer. Thank you very much.
Thank you, Justice Chandrachud, for your erudite words. I express deep gratitude to you on behalf of the entire team Live Law for taking time out of your busy schedule for delivering this lecture. I also thank our thousands of viewers who joined this session live from different parts of the country. Thank you all. Have a good day.